Hey everybody, I just want to take a moment to thank all my subscribers and listeners that dedicate a little bit of time just to hear what I got to say. Thank you so much, but the struggle is real and it continues. Please spread awareness and do your part by making sure that you are subscribed and liking each of the episodes that you listen to. Share my episodes and spread awareness of my channel and what it is that I'm doing. These little things right here is what helps me grow and helps sponsorship come my way, as I am a struggling ex-con. I appreciate the support, the love, and thank you so much for tuning in. More to come. This episode has been brought to you by our friends over at CMB Law. If you find yourself in a tight spot and you need an attorney to trust, call Courtney over at CMB Law, 941-747-4440 or 941-725-9457. You can also visit her site at cmbjustice.com. cmbjustice.com. Again, that's Courtney at CMB Law. Tell them that Thomas FreeMe sent you from the Thomas FreeMe Podcast show. Happy New Year's, man.
Happy New Year to you, sir.
2022.
That it is. Let's make this a great year.
It's an even year. I definitely like to get back into the even years. I don't like odd years.
Yeah. Well, last year wasn't all that great, but I think it's going to turn out all right in the end.
No question. So here we are. We're getting into one of the most important amendments, the First Amendment, here on New Year's Eve as we start off a new year. With everything going on, censorship, YouTube pulling my monetization. This is a very, very important topic that we're getting ready to discuss today.
Right.
How would you like to broach the subject tonight?
Well, I'd like to first point out that there are basically two parts within the Constitution. There's three, but there's two, and that includes the original Constitution, the actual body. That's Article 1 through Article 6. Within that defines the roles of government. We've already been through that each one of the government and the divisions of power are all sealed within those. But within Article 4, it has a clause that identifies the privileges and immunities of United States citizens as well. And this kind of correlates with the amendments itself. So when you're looking at building a case due to the deprivation of a right, what you would need to do first off is you need to, as I said before, rights always derive from those duty to act. So when you look at the duties, you first have to establish, anytime you want to say that you've been deprived of a right, you first have to establish that someone else had a duty to act. And you do that by going into the body of the Constitution and identifying where the actual deprivation occurred. In most cases, it's going to be the judicial branch, because Article 6 says that the judges, both of the United States and of the several states, shall be bound thereby anything in the Constitution or laws of any states contrary notwithstanding. So the citizens of the United States, we have the right to due process of the law because the judges in every state have the duty to ensure that those rights are provided. So within Article 4, Section 2, it says the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. So what that means is that we want to have equality and equal rights and equal application of law among the entire United States. So no matter where you choose to reside within the United States, we want a United States citizen be treated the same. So any right that's secured by the Constitution of the United States and is given to a United States citizen in one state cannot be deprived of that right within another state. And that's what Article 4 is actually doing. Now the next step is that then once you've established someone else had a duty to act, then you'll go into the actual Bill of Rights and you'll identify, the right that's been deprived. So if you've had your right to speak be hindered or obstructed by a courtroom, for instance, then you would establish first that the judge had the duty to permit you to speak freely, truly, and fully to any matter pending before the court. And then you would go to the First Amendment and identify the fact that you have the freedom to speak. And then, of course, then you would go to the 14th Amendment and you would establish that this judge was operating under the color of law and thereby binding the state to the act of deprivation. So That's really important. Now, there's one other thing that I want to say, and that is, and I don't think I made this clear, but there's two different things. There's a civil liberty and there's a civil right. Now, a civil liberty are those rights or those freedoms that are so imperative to the social structure and to the individual autonomy and independence that we have actually established them and written them and enumerated them within the actual Constitution of the United States. So any right that's identified within the Bill of Rights, the first 10 amendments, those are called civil liberties. Those are not called civil rights. Those are civil liberties. And what the intent was to raise those particular freedoms or those rights above any sort of political contemplation. We didn't want them to be up for argument. So we didn't want the freedom of speech to ever be infringed whatsoever. So we've identified it, written it as an imperative right within the Bill of Rights, and therefore it is not to be infringed by anyone, not government or citizen. So so we have those rights. Those are civil liberties that are enumerated there. Now, a civil right is a little bit different. A civil right is actually something that we as Americans, we come together and we want to ensure that every single United States citizen is given this right, and therefore we establish those separately. And what we do is as John Locke said, he said that we gain civil rights as a result of accepting the obligation to enforce the rights of others or protect the rights of others. So as we choose to ensure that we ourselves are entitled to the right to vote, then we must accept the obligation to ensure that everyone has the right to vote. So, for instance, a civil liberty is the freedom of speech. A right to vote is a civil right. Those are two separate things. So the right to vote was in separate amendments outside of the first 10. So any one of these rights that we're about to go over, any one of them are known as a fundamental constitutional right. So when you deal with a fundamental constitutional right, they have such importance that we don't want them to be deprived for any particular reason. So there's an increased stipulation as to whether or not they could be deprived. So there's different types of judicial tests. So the lowest test would be the discretionary test. That would be just some judge saying, I have the discretion to be able to take this right away from you. We don't want fundamental constitutional rights to be at discretion. So we've actually required that they have a much higher judicial test, which is called the strict scrutiny test or the state subjection test. Anyway, so in order for a fundamental constitutional right to be taken away, they have to pass this higher level of scrutiny. And that is that the state has to submit to another organization, another body, justification as to why they have to infringe on this right, why they have to take it away in order to do whatever it is that they need to do. Anytime that a law is applied to strict scrutiny, most of the times it will not pass. There's no reason why the state of Washington would choose to deprive me of my fundamental constitutional right of an indictment by a grand jury, other than the fact that they just don't want to have to follow that law. There's other they can do that. There's not going to be any sort of absolute requirement to take that away in order for them to perform their duties in office or business. So that derives from a specific case called Caroline Products. I think we've all heard of that, strict scrutiny. So in order to deprive any person of a fundamental constitutional right, you actually have to go through strict scrutiny. It has to have a higher level of scrutiny applied to it. Now, there's other rights that are taken away that are not fundamental, and those don't have to have such a high level of judicial test. But any fundamental constitutional right by law has to pass strict scrutiny. So there are some rights that are not included in here, and I'm going to try to remember to go through them, such as the right to intimate association. That would be the right to be able to have familial relationships. You have the right to be a father. You have the right to be a son. You have the right to have those intimate familial relationships without an interference infringement by government. So that is not actually written within the Constitution, but it has been found to be so within or by the Supreme Court of the United States. So again, we have this portion of the Constitution that is in Article 1 through Article 6, which are all the duties. They're duties of the government that identify what they have to do. And one of those is within Article 4 that says that the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. So we do have the right here in the state of Washington or here in the state of New York, the same rights as anyone else. And I think that a great example would be, I believe it was McDonald, but it was a couple years back. It was a couple, a gay couple that ended up getting married, and they moved to Ohio, and Ohio was not accepting their marriage. And so they sued for their right to be married. And of course, the Supreme Court came out and said, no, if you have that right to be married in New York, then you have that same right within Ohio. They can't deprive you of that right. So, we need to remember that the point of the Constitution is to provide unity. It's to provide equality and harmony among all of the regional governments. So we can't be deprived of one right within one state and not in another, or that we're given in another. So we want to just remember that the first part of the Constitution is for the duties of government. The next part is the first 10 amendments. That's going to be the actual rights that are called out where they would be deprived. And then you always need to tie it together through the 14th Amendment, how the state deprived you of a specific right. And that would be how you'd build your case in any sort of civil rights case. That would be the way that you would do it. So one last thing. When I say that rights always derive from another's duty to act, people have been asking me why that is. Well, so the Constitution of the United States, the actual body of the Constitution, it was signed, or it was ratified on, I believe, September 18th of 1787, or September 17th of 1787. So it was signed on that day, and that was first. That came first. So all the duties came before. Then in 1791, December 15th of 1791, we ratified the Bill of Rights. So the duty, of course, comes before the right. Okay, they already established the duty before the rights came along. Now, another reason why that's so is because when a judge takes an oath to enter into office, right? They always have to take an oath in order to enter into their office. That oath is that they will support and defend the Constitution of the United States, okay? And then within the Constitution, it says that the judges, both of the United States and of the several states, shall be bound by anything in the Constitution or laws of any state to the contrary notwithstanding. So when you enter into an oath, what you're doing is you're promising, well, it's entering into a contract. You're entering into a contract with the people, and that contract is promising to perform something at a later date. So if you promise to perform something at a later date, what you're promising to perform is whatever the Constitution says. So when I am arrested, for instance, and I'm brought before that judge, my right to the indictment by a grand jury, my right to the jury trial, that comes well after the promise was made. The judge enters into office, makes the promise, and then later on, I have this right that comes before me. So in order for the judge to enter into a plea bargain, for instance, with me, he would have to violate his right, or he'd have to breach his contract that was originally established through the promise. And then in order to enter into the second contract with me, saying that I'm guilty, which means that the duty does in fact come before the right. My right came long after he entered into office and I established his duty. So we just want to make sure that that's clear, that the rights always derive from another's duty to act. Where there is no duty, there cannot be a right. So we first need to establish the duty before we go there. Okay.
Well, it makes sense. I mean, I don't see how anybody could argue that. It completely makes sense to me. Shall I go into the First Amendment?
Yeah, let's do it.
First Amendment. So before I read this, now again, when they wrote the preamble and they're writing these, like, how was that structure? Were they sitting in a room all together? What was going on at that time? Do you know?
Well, I can't say, but I'm gonna assume that they were all together. I know that the authors and the writers were going off on their own, but they were coming together and they were reading it. They were making sure that every word was exactly what they wanted it to be. So no, I think that these guys worked. I think they worked very, very hard on this document. I think that, other than some fairly significant mistakes that we've already identified, I think that this is a perfect document. I think that if we can eliminate the particular laws that does not conform with egalitarianism, which is that they identified a group of people that were not equal, if we can eliminate that, knowing that it is not applicable to all persons, therefore it violates the principles of egalitarianism, therefore it violates the principles of constitutionalism, then I think that this could be a perfect document. But we need to make sure that any laws that we create are going to be equal and just. So I'm going to assume that they were very, very particular about each and every single word that went into this. And I think you can see that. So another thing here, these are very, very simple. They're not complicated. One of the most important things about law is that it has to be understood. There's three parts of any crime. There's corpus delicti, which is the body of the crime. There's actus reus, which is the actual action that occurred. And then there's mens rea. Mens rea is a guilty mind. You have to have a guilty mind in order to have a crime occur. And, the problem is if you don't understand the laws, then how can you possibly have mens rea? How can you possibly have a guilty mind if the laws are so complicated that you don't even know if you broke the law? That's why this was written this way. It was written very simply so that we know that you have the freedom of speech. We don't need to embellish on that. We don't need to say that it's during certain times or no, you have that, period. And so this Constitution was written very, very simply. It's simple words. It's not hard to follow. It's so that anybody can understand what their rights are. Yeah,
I agree with that. I definitely agree. And doing law work myself, I mean, you can absolutely see how the justices' opinions are. They're more vague than they have to be, and that's on purpose. It's on purpose.
They use a lot of double negatives, which confuses you as they put the double negatives in. You're not sure, exactly what they're talking about. They do that because the reality is that most of this would just require simply yes or no. Yes or no. I mean, they don't need any more. So if you got to write 20 pages in order to explain the reason why, it is what it is, then my hunch is that you're trying to convince people, that your way is right, and try to convince people that it's not the way it's meant to be.
Amendment 1, proposed 25th of September 1789, ratified the 15th of December 1791. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances.
Yeah, so the first part there, the establishment of religion. There's this doctrine of separation of church and state. And I think that we need to understand where that comes from, okay? The Constitution doesn't actually say that you need a separation of church and state. That was actually created, that was a doctrine that was created by the Supreme Court. It was the result of a letter that was written by Thomas Jefferson. It was written to the Baptist Organization of America, and they were asking to establish baptism as the religion of America. And Thomas Jefferson said, no, we can't do that. We're not one religion. We're all religions. We're bringing in all these different people from all around the world that are the downtrodden, the oppressed, and so on. And we're going to give them a place to live. And so as doing so, we need to be able to value each and every single individual and the uniqueness of every individual, the beliefs of every individual. We didn't want a single religion. I mean, even if you don't have a religion, that still is your right. And so there was a desire for separation of church and state, but we kind of forgot what it was. Now, let me explain a little bit better what it is. Is that what is a church? What is a church? Well, it's a place where a sinner goes to get healed, right? So if the place where a sinner goes to get healed would be, in our case, prisons, right? So that would be the place where we would go to get healed. That would be our church. And so there does need to be a separation of church and state, because the state should not be the ones responsible for both being the judge and also for being the ones imprisoning people and healing them, because those two things are in conflict with one another. We need the judge to be a neutral, unbiased third party to act as that judge without having any sort of interest in one way, one point or another. Mm-hmm. And so we need to have separation of church and state, but we need to understand what that actually means. And that means that the state should not be responsible for incarcerating these individuals and getting, financial benefit as a result of these individuals being there. There should be the separation between those two. And that was more than anything what the doctrine was meant to be. But, I think we've taken it and gone a different direction with it. If we are governed as Thomas Paine says, that our king is the law, right? That's what rules over us, is the law. Then that would mean that the law is our Lord, is our ruler. And so when we say that we're going to take our ruler out of schools and out of the justice system, and we're going to take it out of the courts and out of government, then we just took the Constitution out of everything. And then we kind of did. And, the reality is that that's what the Supreme Court would want to do. So when the Supreme Court wants to take the Constitution out of all these things, so we don't know what the Constitution is, so we're not familiar with what our rights are and so on, that's something that the Supreme Court would want to have happen, because they don't want the Constitution to win. I mean, if it did, then once again, they would all be out of a job. So, when you, one question that I have is that why is it that when you go into a criminal proceeding, an adjudication of a crime, why is it that the document or the laws that guarantee your freedoms, you don't use that as a defense? Nobody ever talks about Constitution when you're going through the criminal adjudication process, although they're depriving you of liberty and life. Why would you not go to the originator of those rights and use that as your basis for your argument? I mean, if you brought constitutional law into an argument during the adjudication of a crime, they'd laugh you out the room because they don't care about the Constitution, and they're willing to deprive you of these rights here. So, honestly, I believe that any criminal argument can be argued with the Constitution, and you can find wins. So when you look at the separation of church and state, it's not actually doctrine that's founded within constitutional law. And I actually think we need to bring the Constitution back into our schools. We need to bring it back in because the Constitution is that's the guarantor. That's what fights for us. We need to be able to speak these things, and we need to know what they are. And as we drift away, when you start speaking the truth back to these guys, they get pretty pissed off at you. They don't like what you have to say.
Well, that's what I don't understand. Like this bill, this Constitution, right? This document is our everything as American citizens.
Yeah.
You know what I mean? Why is this not the first thing that we're taught in school? Because everything branches from that.
The separation of church and state. By doing the separation of church and state, they've eliminated this from government. I mean, there isn't a constitution found within the courtrooms. You don't speak Constitution. That's why. What would be the purpose,
Tanawa, of making your citizens ignorant of the rights that they have? What would be the purpose of that?
To be able to enslave them through ignorance, to be able to imprison them through ignorance, to be able to deprive them of the rights so that government can expand. There's Thomas Jefferson. He once said that that when the people fear government, there's liberty, but when the government fears the people, when the government fears the people, there's liberty, but when the people fear government, there's tyranny. And so
right.
He was making the argument that this is the basis for the Second Amendment, for the freedom to bear arms. So what he was saying was that, the freedom to bear arms was a last resort as against tyranny and government. So, when we talk about that the government wants to take away our liberty. They want to get bigger and bigger. I mean, this is an animal that will never get enough until every single man, child, and woman is enslaved.
Mm-hmm.
I mean, until every single dollar is spent on them and given to them, they're not going to have enough. And so, government is always going to be seeking to deprive us of rights and freedoms because the freedoms are against government. It's the absence of freedom that allows for the growth of government. So, with every single act of legislation, we lose a little bit more of our freedom, And so when we have these volumes and volumes and volumes of law that's been established through acts and everything else, then, we lose our freedom. And so you got to look at the different types of law. Once again, I think that when you look at a juris doctorate, that is the adjudication of a crime. It's someone that deals with the adjudication process. So the process of making a person into a slave or a criminal. So, with every law is just simply the absence or the establishment of an obligation. And with an obligation, you lose your rights or you lose your freedoms. So freedom is really the ability to choose on your own. It's not necessarily the freedom to do whatever you want. It's the freedom to be able to make the choice for yourself and for your family.
Mm-hmm.
And so with every single law that's created, we lose the freedom to be able to choose on our own. And so, laws are actually the elimination or the negation of freedom. And so then the restoration of freedom would be the opposite. It would be the removal of laws or the establishment of laws that are unconstitutional and in violation of the supreme law of the land. And so that's what I do. That's what the substantive law is it's determining what is or is not a crime and what is or is not constitutional and legal. So we work to restore the freedom by taking away the laws, and there's just not very many of us because there's no money in this job because our clients don't have money. So we're here for a higher purpose.
How do we get the Constitution back into our schools?
We got to do it ourselves. This is our Constitution. This is our land. These are our laws. We established this. So if you look at it like it's a contract, because that's all this is. Once again, we the people came together, and we the people decided that we wanted these rights and these freedoms. So once again, going back to this, to the social compact, how it worked was that we came together as the people. We said, I want to have the right to live, right? And so therefore we all gave up our right to be able to kill, because in the natural state of man, we have the right to kill, but we don't have the right to live. So we gave up our right to kill in order to give ourselves the right, all of us, the right to live. And so that established the law. And as the laws got so complicated and the social compact got bigger and bigger, we decided, well, we need someone there. We need an entity there to be able to oversee this. And so that's where government arose. So government arose simply for the purpose of guaranteeing those rights that were not given up within the social compact. So government had the right to protect our life and our liberty and our property. Those were three things. They have the obligation to protect each one of those enumerated rights within the Bill of Rights. And so that's the sole purpose of government. It's not all these other things that they're involved in. The purpose of government is to protect the rights of the minority from the majority. And those judges were there to be the defenders of liberty. They were there to protect the minority from the tyranny of the majority. So in order to bring this back, we all have to understand that every single time we take a right away from one person, we just took it away from all persons. So even these prosecutors that are sitting there, they're looking at this person and saying, I'm going to take this right away from this person. They need to think in their own mind that as they do this, they just lost that right themselves, and so did their children. And is this really the direction we want to go? I mean, I don't think that anyone would want to lose their rights to freedom of speech. It just happens. Like the famous philosopher Nietzsche once said, he said, that those who fight monsters should see to it that in the process they don't become a monster. Well, justice has become a monster. It's become a monster in the process because we haven't been holding them accountable for their acts of deprivation. And the only way to do that is, one violation at a time. We've got to fight back.
Well, it's kind of like I always love using this analogy, but the frog in the hot water. If you throw a toad in boiling hot water, he's going to jump right back out. But if you put him in cool water and then turn the temperature on slowly, he'll boil to death and won't even know it. And this is what has happened to us as American citizens, is that they've handed us censorship on a golden platter, right? And how they've done that is through social media, things of that nature, to where we get in the habit of instantly blocking people when we don't like what they hear, just shutting people down and blocking people and not wanting to hear because it struck us emotionally. Right. And we've became a cancer culture now because of that. Now it's whenever somebody's saying that we don't like, we overtalk them, we hang the phone up on them, we shut the door in their face, we just try to block them.
Right.
And again, I feel that these things have been implemented and put in place to slowly boil us to death.
Absolutely. And the freedom of speech is probably one of the most, if not the most important freedoms that we have, because without the freedom of speech, we can't express ourselves. We can't be human. We can't get our point across. We can't hold government accountable for their actions. The freedom of speech is so important that it functions in every one of these rights. I mean, it's all about expressing ourselves and being unique and offering, our debate. So, in 2010, there was a case by the Supreme Court, and I don't remember the case specifically. I believe it was McDonald, but I don't remember. Anyway, in 2010, it was a unanimous court decision. And what they said was that they said that government cannot censor public debate, and nor can it hinder or obstruct free speech in order to control the narrative. This is the First Amendment violation of the most basic sort. That was written by Justice Kennedy. And so when you think about the government, they cannot hinder or obstruct free speech in order to control the narrative. And yet that's what we have every single day in these plea bargain systems, in this justice system, where 96% or 97% of the convictions come by way of plea bargain. And like I said, that's an egregious failure of the justice system, because that's 97% of all defendants that don't even get to tell their side of the story, right? That's government controlling the speech in order to control the narrative. And so, when you look at the witness intimidation or witness tampering laws, it says that no person can have their speech hindered or can have testimony freely, fully, and truthfully committed to a court for any matter pending before the court. So you can't have your speech hindered. Either you are to be given freely, fully, and truthfully the ability to speak on behalf of any matter that depends before the court. So when they prevent you from being able to do it, or they pay you to do it, because that's why it says freely, you are to be given it freely. That when you hire, someone from the outside to come in and speak on your behalf, or the state does, then that's not offering that freely. It's actually offering it at a cost. So that's why I have such a problem with all of these cases of drug cases where they're hiring individuals to come in and frame the individuals to catch them in the act. So anyway,
let me ask you this on the topic of plea bargains, because I was thinking about all that we've talked about surrounding the plea bargains, and how do you suggest a situation is handled where an individual is guilty, and they don't want to go to trial for the sake of the victims, because we always have to think about the victims as well and the trauma that they've been through, and the trauma that they go through, and having to relive that trauma through a trial procedure when an individual is clearly guilty.
Right. So, I thought about that as well, but let me just say that if I could sum up everything that I'm trying to do, it's this. In one paragraph, it would be this: I'm not trying to change the laws. Rather, I'm pointing out what the laws state, and that the ways in which they're being enforced directly contradict with what is specified. Therefore, I'm not trying to change the laws. Rather, I'm asking that we uphold them. If the laws state that something will be done in a certain way, we must follow that way. Laws do not change arbitrarily. That's tyranny. Constitutionalism demands that the laws evolve only through suffrage. Therefore, it's up to the people to decide whether or not the Constitution applies to them, and not a judge or a state. Now, the reason why I say that is because by opening the door and doing something different than what we have on the books, by saying that the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in a state in which the crime is said to have been committed. Nowhere in that does it say that we can adjudicate a crime a different way. So if we choose to do something different, then that's in violation of the laws. So today, plea bargains are in violation of the laws. There's no denying that it was supposed to have been by jury. It's stated both there as well as also in the Fifth and Sixth Amendments. So we know that trial by jury is supposed to occur. But the problem is that as soon as we open up that door and we say, well, we can do it this other way, we either have to have it written in the books before we do it, because otherwise it's an ex post facto law, right? Or we're simply opening up the door and we're allowing for what's already occurred. So if we open up the door and we say this person can come and we'll give him the ability to plead guilty and be found guilty in a way other than the law prescribes, then we're just allowing for this to occur again down the road. So once you open up that door to the prosecutors and you allow a little bit of leeway, then eventually over time that doorway will get bigger and bigger and bigger, in which case we're in the situation we are today.
Well, I'm sitting there thinking, an admittance of guilt is not a plea bargain. You have to go through the admittance of guilt or not guilty process. That has nothing to do with the plea bargain. So I guess in that process, that judicial process, when you're brought in, you're asked, how do you plea, guilty or not guilty. So I guess you would still have that process.
Yeah. And
you should still be sentenced. Like, say, if I go in and I plead guilty, if I go in and I tell the judge I'm guilty of this crime, right, then I get what you're saying. I can actually see that working without a plea bargain deal at all, because you go in and you admit your guilt and you're still punishable by the same sentence as if I would if I was to go to trial and lose. The only thing is I'm just not, I'm saving the taxpayers' money and the victim's grief just by admitting guilt, but I'm getting the same sentence as if I was to go to trial and lose. That's how it should be.
Yeah, and I would agree with that. I do think that it's a good thing when people want to admit that they've been wrong, that they've done wrong. I don't want to discourage that at all. But the one thing that I do want to say is that we have laws, and those laws are reduced to writing. And if they're reduced to writing, then what purpose would they be reduced to writing but to prevent those that are enforcing them to be able to follow them? So if the laws being reduced to writing, if they're able to be at discretion of the individual, or the right to be able to violate them would be of equal requirement as to following them, then of course the laws have no validity. We have the laws and they're in written form, and we need to follow them in written form. Otherwise, we're not a government of laws. We're a government of arbitrary rule of man.
Right.
And that's where we're at today. Is we are under the rule of arbitrary men. We're under the rule of law. And so, I have no problem personally. I'm not America. There's a lot of voters out there. If we want to change the laws, that's what we can do. We can do that. We can change the laws to whatever we want. I'm simply pointing out this is what the laws state, and that we need to follow that until such time as the people have just made the decision to change it. But yeah, I would agree that it's okay, to admit that you're guilty. I think that that's a great thing to do, and I think that's admirable. When you do wrong, you admit to it. But the thing is that there's going to be a change in what we're doing. In the end, I mean, once this is all said and done, and we move forward with the new justice system, it's not going to be about vengeance. It's not going to be about paying for the things that you've done, because paying for the things that you've done, it puts you into debt. It's going to be about compassion. It's going to be about healing this individual and bringing them to a place where they can find healing so that they can go out and not hurt anymore, therefore not hurt other individuals. We're going to change the whole image of justice. And so,
well, that's exactly it, because I think what you're trying to say is that the law favors those that plead guilty versus those that don't plead guilty. And it shouldn't be. I mean, I should not be pressured or feel any kind of way to accept something that goes against my fundamental right, my constitutional right. You know what I mean? And I experienced that, of course, with my case. I was punished for going to trial, and the pressure that was on me to not go to trial. I mean, they're sending family members at me. They're sending whoever they could to try to talk me out of going to trial, which only at the time emboldened me. It gave me more courage to go to trial, because I'm sitting there thinking, man, if they don't want me to go to trial, they really don't have anything on me.
No, but they use that fear and intimidation. They lock you up and keep you there. And all those deprivation tactics are employed in order to get you in a position where you will be willing to plead guilty. So
absolutely, they did.
The issue is not necessarily the plea bargain. It's the abuse of process. It's the abuse of power that they use in order to force you into doing what they want to do, in order to control the narrative, in order to win the case, without any sort of consideration as to what is truth or not truth. Or what
I'll share another quick story real quick, where there was an incident. This is one of the first crimes that I got as an adult. There was an incident with a female, and it was a female that had a crush on me, and she wanted, to have her way with me, and I just didn't have anything to do with her. But we worked together at a pizza shop, that stayed open late. So long story short, we're working one night. It's just her and I, and she wanted to close the shop down and go do whatever she wanted to go do. She called the boss. The boss said, no, stay open. 5 minutes later, right, I'm outside in the car. She comes outside, says the boss says close down. And I ask, well, I hope you clean up. She says, no, I got it. I leave, go to my girlfriend's house for the night. Well, she calls the police, says that I tried to rape her and held a knife to her, all kinds of crazy stuff, right? Now, I don't know any of this. I'm at my girlfriend's house. I go home, and about 7 o'clock in the morning, my father's sitting at the table. So I automatically, I'm like, Dad, what's going on? He's like, some detectives came by here last night looking for you, saying, some pretty horrendous things, but they said that they would come back. I told him, I said, I have no idea. I was at my girlfriend's house. Nothing happened that I know of. I wouldn't, and no incidents or nothing like that. But the point of the story is the detectives came back, and they completely acted like they didn't believe the story at all. The story was a complete farce. You know what I mean? Which was proven. Her story. Okay. Which was proven at trial. I went to trial, and her story was just completely fabricated. We even had the paramedics came in, and it was just a whole fabricated story. It was just one of these stories of a crush, right? Yeah. One of these crushes. So, but the detectives are sitting right there at the table with my father and I, and they're telling us, like, this girl's out of her mind. We don't believe anything that this girl says, but we have to get a statement from you of what happened, and so we can close the case, but we have to get your statement.
Right.
This is what they told me.
Yeah.
So that night, her and I, we were fooling around, just jeffing around in the place or whatnot. And she held a knife up to my stomach and she's like, you're going to F me tonight. And I kind of smacked her hand and the knife went flying. I told her to quit playing, but that was about the extent. We were both just playing around, but I didn't know she had ulterior motives.
Yeah.
Right. She's setting me up that whole time. And I had no idea. I'm just cooling, So the detectives, they told us that, and they're like, yeah, we don't believe anything. Just sign this thing here. So I tell them exactly that. Man, we were just joking around and blah, blah, blah. As soon as I signed it, they slammed the cuffs on me, arrested me for aggravated assault with a deadly weapon.
Yeah.
Right. After they sat there and looked my father in his face and told him that they were not going to arrest me.
They still went forward. Yeah.
Yeah. And that charge has lingered with me all through prison. It has plagued me through my life, even though Tanawa, I went to trial and won. I beat the charge at trial.
Right.
It still followed me through prison.
There's incorrect knowledge base or education within the courtroom. The prosecutor is the highest law enforcement officer in the county. That's what they're meant to be, so they're there to enforce the law. They are under the executive branch. And so, when you look at the education that these prosecutors have, it's the wrong education. They don't know the elements of a crime. They don't know, those three elements, the criminal tehedron. They're not looking at it from that perspective. Their education is literally to find you guilty, to make you a criminal. And so, they're not taking into account the elements of the crime to determine whether or not the crime's even been committed. They just take this information and and they'll charge you based upon the information that they receive, and they'll overcharge you. They do those things because they don't understand crime. They don't understand how crime works. They understand the adjudication, how to make a criminal, but they don't understand, the process of a crime. And I think that a lot of cases would not go anywhere near trial if we actually had someone that was there to look at the investigation and to look at the elements of the crime and to say, what, this person didn't have mens rea. He didn't have a guilty mind because of these elements, whatever. And so I know that we could have a far less workload. It doesn't have to be the way it is today. If one, we didn't criminalize every single thing, and two, we actually cared about the individuals enough to want to help. So there's lots of cases where we can help the people as opposed to harm them. And then three, actually considered the investigation and proceeded based upon, what is or is not criminal behavior and, what is a crime. I think that a lot of things, would change. But the other thing is that a lot of these crimes that we're seeing today are not crimes by a person. These are crimes against government, So, great example would be, a drug offense. If I have drugs on me, and this is the reason why they actually went and decided to remove the grand jury, long ago. I understand the rationale behind it, but government has to be sovereign immune, right? They claim sovereign immunity. And if so, they can't be the accuser. They can't be, right? And the Constitution says so in Article 3, in all cases which a state shall be party, the Supreme Court shall have original jurisdiction. The state can't be your accuser. There has to be the right to confront your accuser. So what happens is that if I get pulled over and I get searched, and let's just say that it was a completely legal and lawful search, and they search me and they find drugs on me, who becomes the accuser? Well, that law enforcement officer would have to be the accuser, right? But he can't be because he's an agent of the state. So what they had to do is they had to create a new accuser, which was information. And they said, here, this information is now accusing you of a crime because it can't be the state doing it. And as a result, there came information as the accuser. And that's why these states are all using this information. But the problem is you can't put that information on a stand and cross-examine it. You can't do it. So your right to confront your accusers completely evaporates the moment that they prosecute you with information only. And that's why, like here in the state of Washington, when they get information, that if that person decides, like in the case of my wife or my ex-wife, she decided that nothing happened. She didn't want to proceed with these charges. And the state said, too bad, we already have your information. We're going to go ahead and proceed with this case anyway. And so then my accuser became, of course, the government. And that was the reason why government says I can't confront the accusation. And as a result, I can't win a case because I cannot confront the accusation. So that information itself, when they receive that information, they just simply say, oh, this is valid. It's truth. And the moment it's truth, you can't confront it. You can't challenge it. You can't refute it. And as a result, you have no choice. You are already guilty in the eyes of the law. So, that's really what's happening. And so, another thing, that just to go with what you were talking about there, because I've heard that a lot. I mean, that very similar thing. That's actually in the Bible. That was Joseph, and what happened to him. But, the central meaning of procedural due process is that the parties whose rights are being affected, that they are entitled to be heard in order to be able to do that and enjoy that right. They first have to be notified. And so when we go back to the grand jury where, for instance, you weren't even notified that there was a grand jury being done, right? You had the right to be heard. I mean, that's a central element of procedural due process, is that if your rights are to be infringed, you have the right to be heard. And this goes back to freedom of speech. I mean, your freedom of speech, you have the right to be there. You had the right to be there all along. And that goes back to a case called Hurtado versus California from 1887. Now, in Hurtado versus California, they actually called out the specific elements of a grand jury. They said that the accused is present and that he has the right to be represented by an attorney. He has the right to speak, and he has the right to confront the accusations. He has the right to call witnesses and cross-examine. All of these were rights that were specifically identified.
And I couldn't even get my jury. I still, to this day, I've never seen my grand jury transcripts.
Right.
Never.
And so you have a freedom of speech issue that's occurring because government is controlling the narrative. They are saying that my client, the state's client, can come and can present their accusation, but the state's opposition can't come and confront the accusation. They're controlling the narrative. They're saying whatever they want, and they're preventing you as a party in the cause from being able to participate in the cause, which is, guess what? That's obstruction of justice, punishable by 10 years in prison every single time that they don't notify the opposing party of the cause.
That's right.
And so when they notify one party, but they prevent the other party from participating and attending in order to prevent that party from being able to speak or be able to present their case and confront the accusation, that's actually obstruction of justice. And it's punishable it's under Title 18-241.
It seems to me that mens rea should be like in the grand jury process. To me, to me, that's what makes sense is that you're brought into this grand jury. The state is making its accusation against you, and it has to provide at that time the mens rea of that accusation.
Right.
They have to show that you knew that you were committing a crime.
Right. So, the point of the grand jury is, so there's all three bodies of or branches of government is represented within the court of law. You have the judicial branch being the judge. You have the executive branch being the prosecutor, and you have the legislative branch being the jury, right? And that jury is there to represent the people. So anytime you have a debt or anytime you tax someone, taxes can only come from the people. It has to come from the legislative branch. The other two branches of government don't have the right to create a debt against the people. And so when you look at the process, that is the purpose of the grand jury, is to act as the sovereign. So, we are sovereign. I think we've already identified that we are the ones that create the laws. And therefore, in order for a sovereign to be billed for a crime, they have to consent. They have to consent to it. So that's the purpose of those jurors to be in there, is to determine whether or not, as the sovereign, we're going to give consent for you to proceed with this charge against this individual. That's their purpose. We are the ones that make the determination as to whether or not there's a debt that's owed to society. Absent that, and the debt is fraudulent, it's not valid, because the executive branch and the judicial branch do not have legal authority to create debt against the people. That is the sole duty of the legislative branch. So all these cases where the purpose and the function of the grand jury has been circumvented, they're not legal. That's fraudulent debt. It's fraudulent debt under the Constitution of the United States, because it was not, the process wasn't followed. The sovereign has to be the one to give the consent, and that comes through the jury. Absent the jury, or absent the proper process of the jury, then you've got fraudulent debt. It's not real. And so that's why, when everybody says, well, why is it that I keep paying for this debt? The reason why is because it was fraudulent to begin with.
Right.
If it's fraudulent, they can bill you over and over. You'll never get rid of the debt because it's not even valid. So think about it. Either A, you've got 9 states that don't even have a grand jury at all, which outright you says, okay, that's not valid at all. But then you have a process issue, right? Where the rest of the states, they say, we're not going to allow the accused to be able to come and confront the accusations against him, right? That's an equal protection issue. because the state is deciding to go ahead and allow this side of the argument, their own clients, to come and present their side of the argument. But guess what? Their opposition does not get to come in. If you were being treated as though you're innocent until proven guilty, you would be there in that grand jury presenting your counter argument and defending yourself. Because guess what? The central meaning of any procedural due process is that the parties whose rights are to be affected are entitled to be heard. And if you're not heard because you were not notified, guess what? That's a violation of due process. That's the most fundamental violation that there is. It's as simple as that. I mean, yeah.
Well, Tanawa, this has been another great episode, man. Impactful, powerful. Again, these are our First Amendment rights. Here, this evening we discussed just the importance of being able to express your opinion, express your thoughts, and just to be able to speak about what you feel is right or wrong, because we're all American citizens. We all live here. We all have to deal with the same stuff, and we should all have the same opinion for it. And as far as it comes for our judicial system, the same applies. I shouldn't be punished for going to trial, and I shouldn't be coerced to take a plea deal.
Right.
It's I'm the one that's accused. I should have the choice of how I want to face that accusation, and it's just not that way anymore.
I think that the most basic thing that everybody understands is that you cannot be punished for having rights or for exercising rights. So when they say to you that either you plead guilty and accept whatever punishment this is, or else if you take it to trial and you exercise your right to speak and defend yourself, we're going to punish you 3 or 4 times more than this. That is being punished for exercising constitutional right. And you can't do that.
You know what my options were? This is when I sat in the office with the DEA, I was in the office with the lead agent, Timothy Lutz for the FBI DEA. Pamela Marsh was my U.S. District Attorney prosecutor, some customs agent, and a couple other dickheads, and they're all sitting in this office. And my options were this. Right? I could cooperate with them, tell them everything I know. I have to wear a wiretap and go set people up, point out drug spots, all of this stuff. That was option 1. Option 2 was go to trial, and I was facing 10 to life. And they told me that if I went to trial and lost, that they were going to do everything in their power to make sure that I got life. This is what they told me. Right. Or I could take what is called an open plea, which is just me going in and admitting guilt, not cooperating, just admitting guilt. And I'm open for the court's discretion to be sentenced, and of course, I give up all my constitutional rights. This is one thing about a plea deal. If you accept the plea deal, you give up all your constitutional rights on appeal, even if they come with a new, some watershed constitutional amendment that can free you. If you took a plea, you're out of gas.
That's actually not true. So under Civil Rule 60B4, 60B4 is specifically for a void judgment. So judgments are either valid or void. There's only 2 ways. They're either valid or void. A void judgment is only void when the court rendering the decision lacks either subject matter jurisdiction or personal jurisdiction. If they lack either one of those, then it's a void judgment, right? And a void judgment is always and forever void. It's never valid. So anytime that a court renders a decision in a case where it lacks jurisdiction, either subject matter or personal, then that decision that's made is non-binding on all parties. It's non-binding because it's void. So that particular court exceeded the power or authority statutorily conferred upon it by the Constitution when it rendered a decision in a case which it lacked personal jurisdiction or subject matter jurisdiction. So in the case of state convictions, and I haven't breached federal yet, that's down the road, but I have an argument for it. But in the case of states, when states choose to become a party in the cause, that is in fact in violation of the Constitution, Article 3, Section 2, which says that in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, which means that personal jurisdiction is specifically given to the United States Supreme Court in all cases in which a state became a party. And as a result, that decision that the state rendered, be it plea bargain or otherwise, it is unconstitutional because the state became a party, and that means that the state no longer has personal jurisdiction, and as a result, it is a void judgment. And in the case of Civil Rule 60B4, in all cases in which there's a void judgment, that judgment is always and forever void. You can appeal to that 20 years down the road, there's no time limit for appealing a void judgment, but that's only under Civil Rule 60b-4. There's other ones like misconduct that only has a year, and appeal for other cases for procedural a year. But in the case of B4, where it's a void judgment, it's always and forever void, and you can appeal that at any point in time. You simply petition the court rendering the decision that for a motion to vacate judgment based upon the absence of personal jurisdiction. Now, that's where I'm going with this. That's where I'm taking this to Supreme Court, and that's where I'm fighting on behalf of everybody. Is that these judgments are unconstitutional. The state doesn't have jurisdiction in a case where it chose to become a party, and
we don't know that. We don't know this stuff when we're sitting in there with these agents and in that office and all that. We don't know that a Rule 60B until we get way down the road and we've exhausted all our remedies and we're like, okay, how do I get back into the court? Well, you can get back in this way. This is how we learn this stuff. Right. But when we're sitting in there and they can tell us whatever they want to tell us, and you believe them because this is the United States federal government. Right. Know.
Yeah, so, my question in your case is, who is the buffer between you and the law? There is no buffer.
It's supposed to be my attorney.
Your attorney works for the federal government. They're representing the federal government.
You know what my attorney told me after all that? After they read that to me, he looked at me and told me. He looked at me. He raised his hands, shrugged his hands. He said, "Well, tell him what you know." That's what he told. This was a public defender. This was, well, in the feds, you don't get public defenders. In the federal system, you get actual pro bono attorneys or whatever, but it's still the same.
Yeah.
It's still the same.
So according to Thomas Jefferson, the purpose of the states were to act as an essential buffer between the central government and the people. They were to be the neutral, unbiased third party. And to do so, the laws were supposed to be coming from the central government. So the accuser wasn't supposed to be a state. The accuser was supposed to be United States of America accusing me of crime X, whatever it is. And that way, every single person across the United States would all be treated equally because the central government, that's the way federalism works, is that the federal government makes the laws in the central government, and then they federate them out to all the regional governments for administration. That way, all the laws are all the same. When you start to deal with states' rights and states' laws, that's actually the Confederacy. That's how that's designed, is that they're all sovereign. They all have their own laws, and they're able to rule the people whatever way they want. That's how it was back in the beginning. And we never changed into a true federal republic, because a true federal republic says that the laws are made by the central government. And that's why the Constitution says in Article 1, it says all legislative power shall be vested in a Congress of the United States consisting of a House and a Senate. All laws were supposed to be made by them. Then they would federate them out to all the regional governments for implementation. And then the accuser then would be the United States of America, accusing you of crime, whatever. And then the judge, not being subject to the United States of America and not being subject to you, would then be able to act in a neutral, unbiased third party in a manner that's neutral. We would have the states being able to investigate the crime without having to work on behalf of the master of the state becoming your accuser. That's the way that the system was designed to be. And how we got so far away from that, I don't know. But when you have the laws that are made by the state, and then you have the state that's the judge, you have the state that's the accuser, you have the state that's the investigator, you have the state that's the beneficiary of the labor that's extracted from the person once they're brought in, into the system, then there is no buffer. There's nothing protecting the individual. That's why the Constitution says that whenever there's a state that's named a party, the Supreme Court has original jurisdiction, because the founders and framers of the Constitution knew that this would happen, and so they identified a neutral, unbiased third party, and the only one that they interpreted as being able to be in that position was the United States Supreme Court. They couldn't use the district courts because those judges arise up out of the state, so they would still have state prejudices and tendencies and things of that sort. But by making the Supreme Court the neutral, unbiased third party, now we have a buffer that can act in that capacity. So it works both ways. Like in the federal system, there is no capacity, there is no buffer, but there is actually, because Article 3 says the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state in which the crime is said to have been committed. The state was supposed to be your buffer. They were supposed to be the judge. The United States of America accusing you of a crime, the state is the buffer. They're the neutral, unbiased third party. That's the way it was supposed to be. And if
the state is my protector, the state, right.
Right. And so you were supposed to have the state be the judge and the defender, and they would act as the buffer between the central government and the individual. And and therefore it works the same way as if the state becomes the accuser, like the United States of America was in your case, then they would bring in a new buffer. And that new buffer, according to the Constitution, was the Supreme Court of the United States. I mean, we're so far off of.
Well, we're so far off of it. You'll have the federal government indict you, and then you'll have the state come right behind the federal government and charge you for the same crime and lock you up twice for the same crime. Right.
There's no difference between state laws or state citizenship and federal citizenship, but yet they've split it apart. That actually comes from the Dred Scott case.
Yep.
Why is it that we're still experiencing Dred Scott over and over again? Why is it we're still experiencing Barron versus Baltimore over and over and over again? Because that was never removed from American jurisprudence. They're still citing Dred Scott.
No, because they're still making money off it.
Exactly.
They're still making money off it.
So if the root is bad, we got to pull the root out, because all of the fruit produced from that root will always be bad. So when we have Barron versus Baltimore, back in 1833, the Supreme Court says, guess what? You don't get the rights identified within the Bill of Rights. You don't get them. And then today, that is still standing Supreme Court doctrine. That decision flowed out to every single one of the regional courts, every one of them. So from that moment forward, until Barron versus Baltimore is completely removed, and all of the progeny coming from it, and the court puts into place to all the regional courts, right? If they put into place a new precedent that allows for the correct application of the law, until that happens, every single case is unconstitutional because they derive from an unconstitutional ruling from the highest court in the land. I mean, it's as simple as that.
Tanawa, thank you for your time. Happy New Year, man. And like we discussed at the top, it's going to be a great year, man. I really feel it is.
Yeah.
We've weathered the storm, partner. We've weathered the storm, and
tipping point. We're past the tipping point.
We're past the tipping point. And it's I think that the skies are just starting to clear for us now. So it's just making the right choices from this point on, and just being our best selves and putting love first and knowing that's going to be returned to us. So until next week, my friend, the Second Amendment. I know people are waiting on that. We're going to get into guns and we're going to get into more stuff. So tune in. Thank you once again. And take care, partner. See you next year.
God bless. Thank you.